I am Helen Wright, Senior Impact Manager at the Dixon Poon School of Law, King's College London. Welcome to Research in Action, our new podcast bringing you research from the Dixon Poon School of Law community, which is shaping law, policy and society. Hear conversations with leading experts from King's College London and beyond, as they reveal how their work impacts the world. Our academics aren't just working to address today's most pressing legal challenges, they are driving the debate.
I'm Helen Wright, Senior Impact Manager, and in this episode we're talking to Dr Trevor Clark, who's a Senior Lecturer in International Finance Law. His research focuses on international finance and corporate law and the lawyers and law firms that practice in this sector. He's published extensively in the area of international finance law, corporate law and the legal ethics of lawyers who work in international law firms. His most recent publication is Financial Markets and the Ethics of Legal Practice from Oxford University Press, and it explores how lawyers shape and are shaped by financial markets and draws on extensive interviews with partners and senior associates working in major international law firms. Hello, Trevor.
Hi there.
Welcome. The first question is about the actual practice of conducting the research. So how difficult was it to do this kind of empirical research in this environment and in this world of international law firms? It seems that there might have been some challenges there.
Yeah, I mean, it's one of those hard to reach research settings. I think, previous researchers have had some difficulties, and it was very good of you to mention the book in your intro. So in the book, I talk quite a lot about the research methodology that I adopted. What I would highlight is what you're dealing with is opacity in two respects. One is private international law firms. These are global but very private businesses. And then on top of it, you've got the global financial markets in which they are deeply immersed. And so you're having to do two things, really. One is to understand the internal dynamics and drivers of these global law firms. And the second thing, which is almost a barrier to entry, if you like, is to understand the type of work they're doing, the clients they're acting for, and the challenges, including ethical challenges. On the other hand, and I guess the final thing is individual lawyers that I interviewed are reluctant to come forward for academic research. They're also quite guarded, particularly when you're talking about issues that impact on ethics. On the positive side, I would say I had some advantages. One is that I had a very long career myself, and to some extent I'm expert in financial law or financial markets, and also I was a partner of a law firm for many years, so I'm also familiar with the internal dynamics. And that got me across some of those credibility type issues. It got me a bit of access, I guess, that I might not have got otherwise. But also in the interviews themselves, people felt quite relaxed, quite open. And also through the methodology that I adopted as well, I guaranteed anonymity, used open questions. Out of that came some really interesting and I think important data.
When you talk about international legal practice, what do you mean? What kinds of lawyers and firms are you focusing on?
So my focus is international law firms, and those are these days they've grown to become global business organizations. The largest law firm in the world has got over 8,000 lawyers working in it in about 60 different countries, and they're advising some of the most important business organizations in the world, and the transactions that they're advising on are the most important. They shape the markets. They're multi-billion-dollar often, and they're cross-border. They often involve parties in a number of different jurisdictions. One thing I would say before we move on is I was very proud to be a partner of a law firm. It's worth saying that the legal services, particularly in the UK, but in other jurisdictions as well, is something of a national asset. We export services, financial services, and legal services are major contributors to the UK economy, and it's an industry of which we should be proud. The reason I say that is because I think it's an industry we need to protect. There will be a lot of focus in this discussion on risks emanating from law firms, but also I think we need to think about risks impacting law firms that come from this type of ethical misconduct research.
Thank you. Your article references high-profile lawyer-related scandals. Could you explain one of those examples, and highlight any key lessons from that?
In the entertainment industry initially, but actually broadly across the business world. And probably the most high-profile case was that of Zelda Perkins, who was Harvey Weinstein's personal assistant. She blew the whistle on some behavior by Harvey Weinstein, and then was subject to a settlement. And she was effectively coerced into signing a very one-sided non-disclosure agreement. Now, non-disclosure agreements are used in the business world to protect financial information quite legitimately. But when they're used effectively to suppress behavior in an employment context, then solicitors really need to focus on how those are drafted and the process leading up to their signature. And in the Zelda Perkins case, and there are obviously myriad other examples, that's possibly the most high profile. And there were provisions in that agreement that said that she couldn't seek medical or counselling support without the approval of the law firm that acted for Harvey Weinstein. The process of signature was very intimidatory. She was taken to an office at the top floor of a building, and basically it was a sign or you don't get the money type process. And that led to the SRA issuing a warning notice, reminding solicitors of their ethical duties, but very high profile because it all came, it was part of the whole Me Too movement. And again, lawyers very closely involved because the law firm that acted for Miramax, which is Harvey Weinstein's company, counterparty to the NDA with Zelda Perkins, was a very high-profile international law firm headquartered in London.
What type of ethical decisions are happening that do play into the impact on financial transactions and financial markets?
What I did in my work is focus on a particular practice area within international law firms, which had some media scrutiny. So journalists have started to comment on lawyers involved in the areas called leveraged finance or leveraged buyouts. And what was happening there was that lawyers were acting without independence. There was conflicts of interest, and the effect that was having was to affect how contracts in that market were evolving. Very simply, they were very one-sided. So one side was losing all their protections, and that side involved a lot of banks. But also those contracts were developing not only in a way that was just overwhelmingly one-sided against the lenders, but also they had lots of problems. The documents didn't work very well. They were littered with ambiguity and potential loopholes that could be exploited by borrower lawyers and had been exploited by borrower lawyers. So what I'm trying to do there is identify how lawyers can, so don't keep to the ethical line. That can have implications for them potentially, but actually there are broader systemic consequences because, and I can give an example
Yes, please.
if you like. So in the leveraged finance world, it's really mergers and acquisitions transactions, again, cross-border, very large scale, often billions of dollars. And it's one company buying another company. Usually the purchaser is private equity owned. And the key element in a leveraged buyout is the leverage. So the purchaser is borrowing about 70 to 80% of the purchase price. And so putting in a relatively small amount of their own money, but then going to finance market to fund the majority of the purchase price. And then the banks syndicate that debt to other lenders. The issue that I've identified and I'm connecting to the role of lawyers is issue around the problems in documents. And one specific example is that the documents provisions often duplicate each other, often contradict each other, and have all sorts of flaws and ambiguity embedded in them. And one specific example is in the financial covenant. One thing that is really important for lenders historically is to be able to monitor the financial performance of their borrowers. And if that starts to fall away, they can take protective steps. A lot of those protections have gone. And one example is a provision that would allow lenders to monitor the amount of total borrowing a borrower has. So for a lender, that's absolutely critical. And through what are called EBITDA add-backs, and so that's a financial metric, but lawyers have introduced all sorts of subjective adjustments into the drafting. And so it's now really difficult to firstly calculate with any certainty what a borrower's total indebtedness position is. What that means is, and this is not just me saying this came through my interviews, but also we've had an international body, the International Organization of Securities Commissions, which is a sort of supranational overseer of domestic financial services regulators like the FCA, for example, in the UK. They pointed this out as well. What it does is it disguises a company's overall indebtedness. And that means the lenders, and that includes banks, but also includes all sorts of other investors in the market. They just can't accurately understand the risk they're taking on. And so they can't properly price that risk. Until you can understand the risk, you can't put a price on it. For example, the FSB, the Financial Stability Board, which was established in the wake of the global financial crisis, has pointed out they see these leveraged finance documents both creating what they called an unprotected asset class, where lenders were not getting their traditional protection. But also they said they didn't think the risks of that asset were priced in. In other words, What that means is you've got a lack of transparency in financial markets. And that really was the issue behind the 2008 financial crisis. And there have been some recent warnings, including by the Governor of the Bank of England, that another 2008 could emanate from this leveraged finance area. There are a number of reasons why that could happen, but one of them is a lack of clarity in leveraged finance documents and also connecting that to the activity of lawyers.
And so when did those sort of practices start, and why did they start? Have they always been there, or have they evolved over time? Or is this is this new?
The process started in around 2005. So we started to see dynamics or macro dynamics in leveraged finance markets shifting. And there's a whole number of reasons. And what that did was reverse the bargaining power between lenders and borrowers. Until the mid-2000s, lenders could protect themselves. Loan documents were, if anything, pro-lender, but they reflected the fact that lenders take on the bulk of the risk in a loan transaction. They advance money and then expect to be repaid. And so there was a lot of protection in these documents for lenders. But as the supply of this debt, more and more lenders came into the market, that bargaining position reversed, and then came the fact that borrowers could insist on tougher terms. And in this process, what I'm arguing in the book is that lawyers don't operate in a vacuum. They are shaped by these types of dynamics. They do, independently of those dynamics, then shape those markets. So that is the argument that I'm making in the book. Now, an example of that is this practice. I don't know if now is the right time to get into it, but this practice called lawyer designation, which started around about that time. So we're talking about mid-2000s. As I mentioned, in this market, we have a loan transaction. Could be multiple billions, could be lots of different tranches, very structured. But essentially, at the heart, it's a loan between a lender and a borrower. Both the lender and the borrower are independently advised by an international law firm. So far, so normal. What is unusual about this market and how it developed, pre-2005, the lenders chose their own lawyers. However, pre-2005, the borrowers pay for their lawyers. Now, that's not unusual in lending markets, in finance markets. What is unusual, from 2005, the borrowers, who are often private equity owned, started saying, if we're going to pay for our lenders' lawyers, we want to be able to choose them. And it was that shift just meant that the lawyers for the lenders, although they acted for the lenders were their client, they were now getting all of their work from the borrower of the transaction. And actually the borrower, the private equity owned company, was delegating that power to their own law firm. So what you had is a series of referral relationships between large international law firms and individual partners, where the partner, sort of big American firm X, who acted for the private equity-backed borrower, chose who would act for the lenders at UK firm Y and would select a particular partner. So what that means is, in terms of ethics, is the lawyer acting for the lenders had divided loyalties, had its client relationship with a lender, a big bank or a group of banks, but it was getting its work, not just on this transaction, but would expect to get its work on future transactions from one or more lawyers at other law firms. And so they had this, essentially a conflict of interest, but also severe challenges to their ability to act independently. The independence issues, there were two. One is, could they act in the best interest of their client, the lender, when they're reliant on this flow of work? And two, are they thinking independently of their own commercial interests in securing this ongoing flow of work? And would they perhaps be taking into account the interests of a third party, in other words, the borrower and its lawyers, as a result of this practice of designation? The consequence of this has been, and my research provides evidence of this, is that lawyers on the lender side were so concerned about effectively being blacklisted or cut off from that flow of future work that it changed how they behaved in negotiations, and they stopped providing a sort of a robust and a rigorous review of documentation. Their comments became shorter and shorter. Their issue list became shorter and shorter. The type of language they used when they were advising their clients became very anodyne and neutral. It wasn't clear to clients whether this was an issue that was needed to be raised, and pushed back on, or could be quietly dropped. Meanwhile, on the other side, the private equity borrowers' lawyers were being very clear what they could accept and what they could live with. The effect of that was, was to aggravate this trend towards overwhelmingly favourable documents in favour of borrowers, but also at the same time, these problems with documents that I mentioned earlier were not being picked up. Lawyers on both sides just stopped fixing problems with documents And that was because the borrower's lawyers didn't want them fixed because of the nuances of lending markets. For lenders to protect themselves, they need very clear rights in the agreement. The borrowers, to stop lenders protecting themselves, it helps them to have ambiguous provisions. So ambiguous provisions help borrowers. So that the effect has been that lenders' lawyers haven't picked up and insisted these documents be properly drafted. And that's what's having these systemic effects, these effects on transparency.
From an ethical perspective, you emphasise the traditional duties of lawyers: independence, integrity, competence. How are these challenged or compromised in which areas you identified within your study? So, like, how has that changed? How has that impacted on the traditional values?
I mean, what is interesting, I think, about this area generally is the previous research on how much lawyers actually know about their ethical duty. That I'm a former lawyer myself, and it wasn't something we were particularly heavily educated in, and there were some rules of ethics we were quite familiar with. For example, conflicts of interest. Some of these other duties, independence, integrity, are a little bit more virtues based and maybe less clear. All the other difficulty is for lawyers in practice is, even if you're aware of what your duties are, do you necessarily identify a problem as having ethical aspects? And we're all very good at morally justifying if the situation allows us to do various things. So first of all, you've got codes of conduct, but that lawyers don't necessarily know the detail of those. And also in practice, are they necessarily connecting those duties to the situational pressures that they're faced with? The key issues around independence were for these lender lawyers that they weren't able to think independently of their own commercial interests. They were also they were also influenced by a third party, so a party outside of their own client relationship. And there's clear evidence of influence. Not acting in the best interests of their own client. There clearly were issues around whether they were giving their lenders the same level of advice as the client on the other side of the negotiation table. I talked about integrity around processes, threats and coercion, competence again around the quality of the documents and what that has meant. That's kind of quite serious implications, I think, for markets.
And why do you think that the legal profession has historically escaped this sort of scrutiny that the financial sector has had?
Yeah, it's a really good question, and one that continues to surprise me. But there was a bit of scrutiny on the role of American law firms following the collapse of Enron. We haven't really seen anything similar in the UK. And as you said, after the financial crisis in 2008, there was a huge public blowback against bankers, but there was a real silence around the role of lawyers. To come back to your question as to why do I think that is, I think one is that there's just this barrier to entry, understanding what lawyers do. I don't think there's been a lot of scrutiny from media or from academics. The other thing I would say is there is this traditional conception of the lawyer's role, and we call it, in philosophical legal ethics, we call it the standard conception, which sees lawyers as neutral. So all they do is they are neutral from their clients, and they advise their clients. They lay out the options, and the clients choose from a menu of options. If you take that view, then the argument goes that lawyers should then not be accountable for the consequences of their advice. Actually, that isn't what happens. Lawyers exercise significant discretion on a daily basis, have real influence, as I argue in the book, on how markets develop, and I think as a consequence should be accountable. Lawyers were kept out of the senior manager regime. So after the financial crisis, one regulatory response was to identify managers in each department of a bank who were responsible for each function and say, well, actually, if a major problem happens in your department, you will be personally responsible. And it was an accountability regime. But lawyers were excluded, and partly it was for this reason that the lawyers argued that we don't have any influence, we just advise. But actually, lawyers within major banks have major influence, and they're real gatekeepers. They say yes or no to transactions and have real power. So I would say a contested and it's a misconception of the lawyer's role, but it's still quite influential in practice. So I think that's another reason why there's been less scrutiny. I think there's another issue as well, is it's assumed that lawyers are being properly monitored. But when it comes to the activities of lawyers in large law firms, in financial markets, legal services regulators are not really across all of that for reasons I could talk about.
Can you see a scenario in which a major law firm becomes a focal point of a systematic risk event, which is similar to the banking crash?
I mean, I think it's a possibility. The reason I say that is, well, we have an example in the accountancy world after the collapse of Enron. At the time, there was a big five of accountants. One of the firms, Arthur Andersen, ceased to exist because it was implicated in alleged illegal activity involving Enron. It was subsequently cleared of wrongdoing, but not before all of its clients abandoned it. So it effectively collapsed. And law firms are subject to similar fragilities. So there is the potential for, if one or more law firms are closely associated with an ethical scandal, which also has systemic type implications, that something similar could happen. And that's why I said at the beginning that part of this is about thinking about understanding what causes systemic risk, thinking about the role of advisors, including lawyers, in, if not creating, but aggravating systemic risk. That's partly protecting society from unethical conduct of lawyers. I think there's also a responsibility to protect lawyers and law firms. And what can we do to protect lawyers from ethical risk? Can we just, instead of leaving these ethical smoking guns, as I call them, like lawyer designation, and just seeing what happens, letting the market regulate them, let's just take them out. We know that creates problems, divided loyalties for lawyers. We know that that's potentially going to have implications for how contracts develop and the build up a system. So let's deal with them. Let's protect lawyers. Let's not even give them a choice on things like that. And let's protect this, this national asset.
So what other examples are there apart from lawyer designation? Is there what else could happen? So you could take out that particular thing, and that will provide protection on and benefit many parties. But what else?
I think in terms of how we might react to this research, what might we do but better in future? What does accountability look like? I mean, we've got, I would say, an accountability gap. We've got lawyers saying, we don't decide, we just lay out options for our clients. They decide. The clients in return are saying, when they do something, when they're picked up for doing something wrong, they say, well, we acted on the advice of our lawyers. So there's a bit of an accountability gap. I think one way of addressing that is to make lawyers more accountable. We should have an amnesty in this area for the things that happened in the past, but we should tighten up our approach to regulation going forward. I think the important thing there is it should be a joint effort between legal services regulators and financial services regulators. I think there's a danger of these sorts of issues falling between these two stools. The legal services regulators are under-resourced. They are probably rightly primarily focused on protecting the consumer. They're really focused on misconduct in high street firms, for example, but they just don't have the resources to really properly monitor what's going in the international law firm sector. So more resources needed, but also an appreciation that side of legal services is not without risk. But also there's this issue I keep coming back to, which is it's quite difficult to understand what lawyers are doing in financial markets. Financial services regulators are really well placed to do that. They know how markets work, and they maybe need to be educated a bit more on the role of lawyers in financial markets. So there's a real danger that this sort of issue is falling between the two types of regulator, legal services and FSA. So I think dealing with these specific issues like designation, there's another one I talk about in the book. It's called trees in the head, and it's where, just very quickly, where you have multiple banks bidding for the mandate or the first stage of a transaction to arrange this leverage financing, and they're competing against each other. At one time, they would have all been individually represented by different lawyers at different firms. And then it became, and that's quite expensive, of course, because the borrower is paying all those costs. So the borrower then said, well, can't we have different partners but at the same firm? So every bank would be represented, and we've put information barriers in between each partner, but they would be partners of the same firm, and that would be cheaper and easier to organize. And even that creates the risk of leakage of information between clients. What I talk about in the book, and this is again a reflection of the power that borrowers have and a weakness that lenders have to say no to some of these things. Now it's one partner within the firm acts for, say, 10 different banks all competing with each other, and they have to erect those information barriers within their head. So instead of having a physical tree, so with all these branches with different partners acting for different clients, they have what's called a virtual tree. They have to basically separate within their head, compartmentalize the sensitive information of each client. And what I found in the book talking to people is that there is no faith in this process, that there is no real belief by anybody I spoke to that that information is not being leaked between different clients, often just by mistake, because that single lawyer is under so much pressure, acting for so many clients. They've got sensitive information for 10 different clients, that each client, if they knew the information of the other client, could use it to their advantage. Classic conflict of interest situation, but that information is leaking. And
it sounds impossible. It wouldn't. So how did that process from going from it being different partners in the same firm to being one partner, how did that happen? Because that would seem to be very problematic just from an outward perspective.
I mean, one of my interviewees said it's just a misnomer that, you can't erect these trees in your head, these barriers in your head. One person can't. There's a section in my book where I talk about how it happened. So, it happened over time where law firms should have, acting for lenders should have said, no, that's a step too far. We're not going to do that. But, by not participating in this activity, then they risk not getting the future referral work. But there should have been a line in the sand drawn there to say, no, we're not going that far.
So if you could change one thing about how the legal industry approaches ethics and risk, what would it be and why?
I think if I had to pick one thing, it would be that I hope this work where is building a case for more focus from regulators. And I think it's that point that I mentioned earlier. We really need legal services regulators to join together with financial services regulators to confront this issue. And we need tighter regulation, to deal with specific issues like this. This is a case study. This is case study of leveraged finance. It's probably quite an egregious example. I'm not suggesting this happens in other pockets of law firms or other pockets of financial markets at anything like the same extent. But it really is I hope, we can't take for granted that problems won't emerge, even in these amazing, excellent international law firms. There's still the potential for this sort of problem to arise. So I think sort of clearer regulation, it's a little bit too vague. It's sort of principles based, a bit more monitoring of what international law firms are doing. That needs more resources. I recognize that. There might be a cost through some sort of levy for law firms to pay for that. But I think if we want to take these sorts of risks seriously, then we need a new joined up approach. There's a role for law firm leaders to play here as well in taking these sorts of risks seriously, creating ethical climates within law firms, making sure their individual lawyers are properly protected from these sorts of risks. So it's not, I'm not just saying it's for regulators, there is an issue for the profession to take seriously here.
And for current or future lawyers working in the international finance space, what ethical dilemmas should they be aware of now?
What I would say to anybody lawyers, and I teach lots of students who are obviously interested in pursuing a career in international law firms, and I would always encourage them to do so. I had an amazing career. I traveled a lot, worked with some really impressive people on some amazing transactions for some amazing clients. So I wouldn't let any of this detract from going forward into that world. But if you're thinking about going into that world, then you are going to be presented with ethical problems. So there is a responsibility, I guess, on the firm to make sure that their lawyers are properly educated on these issues, both on what the rules are, but also how they apply in practice. And using this type of data, I mean, one thing I really hope this book does is expands the evidential data, and it really gives people an insight. I would encourage students to have a look at this book, because even though they may not work in leveraged finance, these types of issues, these types of ethical pressures are going to crop up in similar forms. But ultimately, junior lawyers are not in a position to make a call on whether a firm should take on a particular piece of work, but for a particular type of client. This really needs to come from the leaders. There's a lot of focus on things like whether law firms are properly making a contribution to the community through their community outreach programs, for example, and pro bono work. And students are rightly focused on which firms are doing that appropriately and correctly. Students are worried about the moral dimensions of some of the clients that law firms act for. To what extent are they distancing themselves from climate or polluters or fossil fuel companies? Students are really focused on that. Some of the stuff that I'm talking about is much more opaque. It's really difficult to put your finger on for all the reasons I've mentioned, but the students should be equally focused on that sort of thing. What are firms doing to build an ethical climate?
Thank you. Well, thank you very much for sharing your insights today, Trevor. If you would like to find out more about Trevor's work, the book is available, I'm sure, for more reputable booksellers.
Yeah, available at Amazon, and other sellers are available.
And the details will be included with the publicity that we put out alongside this podcast. If you'd like to follow up on anything you heard today here, please do get in touch with us here at the Dixon Poon School of Law. I'm Helen Wright, and thank you for listening. Thank you again, Trevor. That was great.
Thank you very much, Helen. Thank you for all those great questions.